Supreme Court, in the matter of Patel Babubhai Manohardas versus State of Gujarat, allowed the appeal and set aside judgment and order of High Court and Trial Court. Prosecution case was that one Jaya Balaban lodged FIR before the Mehsana Taluka Police Station on 14 May 2009, stating that at 8 a.m. on 24 April 2009, she and her daughter Priyanka had gone to Amipura Water Park Dispensary as she was working there. At around 1 p.m., one Jayantibhai Kalidas, a neighbor, came to her dispensary and told her that her mother-in-law was ill. On hearing this, she and her daughter came back home immediately in a rickshaw. When she reached her house, she saw many people had gathered there. She went inside the house and saw her husband Dashrath Bhai Karsanbhai lying on a cot with his younger and elder brother standing nearby. Though she tried to revive him, he did not respond. He had already died. As she started weeping, ladies who were present there told her that her husband had consumed poison. Foul smell of poison was coming from his mouth. First informant stated that her husband was taken to village dispensary where he was declared dead. J. Balaben continued with her narration. She stated that about a year ago, a case of misappropriation was registered against her husband, Dashrath Bhai Karsanbhai, in his office. She and her elder brother-in-law, Jantibai, had asked her husband as to why he needed so much of money, to which reply of her husband was that one cleaning worker in his office by name of Geeta Ben had trapped him in a love scandal and thereafter started blackmailing him for money. It is for this reason that he had to withdraw money from the office to give to her. Supreme Court said that the abetment to commit suicide involves a mental process of instigating a person or intentionally aiding a person in the doing of thing. Without a positive proximate act on part of the accused to instigate or aid in committing suicide, conviction cannot be sustained. Besides, in order to convict a person under Section 306 IPC, there has to be clear mens rea to commit the offence. In the case of Kamaruddin Dastagir Sanadi versus State of Karnataka, court observed that discord and differences in domestic life are quite common in society. Commission of suicide largely depends on mental state of the victim. Until and unless some guilty intention on the part of the accused is established, it is ordinarily not possible to convict the accused for offence under 306 IPC. There were significant inconsistencies in the evidence given by the prosecution witnesses in this case. Court said that there is nothing on record to show recovery of any jewelry by police from the accused person. No signed checks of deceased or checkbook or passbook of deceased were recovered and exhibited in court. In such circumstances, very substratum of prosecution case that accused persons were making illegal gain by blackmailing the deceased fall flat. Cause of death was due to consumption of dichlorovus organophosphorus non-theo poison. As per post-mortem report, doctors said that if anybody drinks such poisonous substance, then this type of death can happen. But there was no recovery of any trace of the poison consumed by the deceased at the place of occurrence. No bottle or container of such poison was recovered from residence of deceased. Moreover, prosecution could not take place before court any material as to where from the deceased had procured this poison came. Sum and substance of the suicide note allegedly written by Dashrath Bhai Karsan Bhai Parmar. The date given was 24 April 2009, when appellant had joined his office following illness of existing cleaner. She used to come to the office daily for cleaning purposes. Slowly they developed intimacy. It was alleged that appellant number 3 had performed black art on the deceased, so much so that he fell in love with her. Taking advantage of the situation, she took photographs and video of them in compromising position. All accused persons were shameless persons. As they started blackmailing him, he initially paid rupees 80,000 to them and thereafter started giving them ornaments. He also gave them his passbook and checkbooks, and after signing on the checks. Because of such blackmailing, he had to misappropriate money from office, for which he was suspended. It was stated that it totally ruined him and therefore he committed suicide as he had no other alternative. Suicide note was sent to Forensic Science Library for examination. Deputy Chief Handwriting Expert of FSL Gandhinagar opined, opined that the handwriting was of deceased. However, prosecution did not examine the Deputy Chief Handwriting Expert as expert witness. In case of Murali Lal versus State of Madhya Pradesh, Supreme Court opined that having due regard to imperfect nature of science of identification of handwriting, approach of the court should be one of caution, where the reasons for the opinion are convincing and there is no reliable evidence throwing a doubt. Uncorroborated testimony of handwriting expert may be accepted. The Supreme Court held that even if we take the side note as correct and genuine, we do not find any act of incitement on part of appellants proximate to the date to which the deceased committed suicide. No act was attributed to appellants proximate to time of suicide, which was of such nature that deceased was left with no alternative but to commit suicide. In such circumstances, court said that it cannot be said that any offense of abetment to commit suicide is made against the appellant.